Hi, my name's Katie New, and I'm one of the attorneys that works at the Liker Law Firm. Today I'm going to talk about reaffirmation agreements. When filing for bankruptcy, debtors have a number of important decisions to make. You can surrender property through a bankruptcy, even property that still has a loan balance. Some debtors choose to retain certain types of property, including vehicles and homes. If a debtor does choose to keep the property, it would still need to be disclosed on all of the bankruptcy petitions. However, we would just indicate that you would not be surrendering, that you'll be keeping the property. In some cases, if you choose to keep the property, the lender will want you to sign what's called a reaffirmation agreement. A reaffirmation is a voluntary agreement that would need to be filed within 60 days of your creditors meeting or before the case is closed, whichever is sooner. The agreement states that the debtor is continuing the loan and will continue to make payments in accordance with the agreement. If the debtor chooses to sign a reaffirmation agreement, the debtor is responsible for the particular debt as if he or she never filed for bankruptcy. Even if a debtor chooses to sign that reaffirmation agreement, you have 60 days after the agreement is filed with the court to rescind the agreement to reaffirm the debt. Whether or not a debtor should sign a reaffirmation agreement is a very important decision, and there are a number of factors to consider. Signing a reaffirmation agreement might allow the debtor to keep certain types of property, including things that might be very sentimentally important to a debtor, like a house. A reaffirmation agreement might also allow a debtor to keep certain types of property that are very practical, like a vehicle. So the issue becomes whether or not you can truthfully afford that property. If when all of your other debts are eliminated, you could actually afford the ongoing payments, it may be a decent option for you. If you're still going to struggle to make those payments, you may want to consider other options. Some debtors are concerned that with filing for a bankruptcy, they won't be able to qualify for a new car, a new house, or even a rental property. If you're talking about vehicles, we can certainly make a recommendation. There are lenders that specialize particularly with working with people that have filed for bankruptcy. There are certainly options available, and in some cases you can even get into a lower interest rate or a lower payment, something that you can continue to afford after the bankruptcy. The reaffirmation agreement effectively eliminates some of that fresh start. You do have those ongoing payments, so you want to make sure that you can truthfully afford them. It would be unfortunate to reaffirm debt that you could have surrendered in the bankruptcy, to then fall behind in those payments and face a repossession or foreclosure anyways. Even if you can afford it and it is property that you want to keep, there are some other things to consider. You will be subject to fees. There will be attorney's fees, there will be lender's fees, and of course those ongoing payments. There certainly are options to consider, and you may want to talk to an attorney about this. The biggest thing is that you're assuming the original contract again, and you don't have to. This is an entirely voluntary agreement, so you want to make sure it's the right option for you. In many cases, the debtor is frankly better off to just wipe it out and to look into a new vehicle, something that's more affordable. If you still have questions about this, please feel free to call and make an appointment with us. Thank you.